What was Puckett versus Rufenacht, Bromagen Hertz, Inc.?
I represented RB&H in that case, a Chicago brokerage firm that had a branch office in Hattiesburg, Mississippi. And the plaintiff in that case was a retired doctor who would, and this was the days before electronic trading where you could trade from your computer at home or things like that. But he would actually go into the commodity office each day and trade. And he would not ask for any advice from the broker. They gave him a seat by one of the screens that they used internally, and he'd watch the screen. He would tell them when to buy, when to sell, and he was doing all I believe was the S&P 500 futures at the time. This was the late 80s, and he lost about $2 million doing this, and it basically emptied out his retirement accounts. He took out his retirement money because he was just every day in there trading, not doing well, thinking he would do better the next day, apparently. And eventually his kids had to stop him, and they found out about it, and they, forced him to stop trading. Well, he claimed that the broker should have stopped him, that he was some sort of sickness that he had, or addiction to trading, that the broker should have noticed this and should have stopped him from trading. And at that time, there was a lot of talk in the industry about, does a broker have a suitability duty for a customer? And there have been some litigation over that, nothing really definitive. We took the defense, basically, that, these were non-discretionary trades. He did them on his own. He didn't even get advice. He didn't even get recommendations. This came from his own knowledge of the stock market, and that the broker just doesn't have a duty. You never know when he would come in the next day and make it all back and more, because and he could sue you for stopping him if that were the case. We persuaded the district judge to rule as a matter of law that we were right, that there was no suitability duty. The plaintiff took it up on appeal to the Court of Appeals, and they said, well, under federal law, you're right. There's no suitability under the Commodity Exchange Act, but Mississippi has no law on this subject. They're not a commercial state. They did not have any law on the duties of a broker. And so we're going to send this to the Mississippi Supreme Court and let them decide what Mississippi law is, and then they'll report back to us, and then we'll decide whether you have a claim under state law. And so I went down to the Mississippi Supreme Court. It was kind of an unusual argument, I think, in the sense that there were 9 justices on the Mississippi Supreme Court, but only 3 heard the argument. And I think they tape recorded it, but all 9 voted on the case. So it was, and they used the old long legal paper too, which was, it gone long ago from other jurisdictions. And I could tell in the argument, one of the judges was not friendly to us, and the other 2 you couldn't really tell. But ultimately we did win the case. One of the examples they used in the opinion was, if you walked by and saw somebody about to jump out of a window and kill themselves, you would have a moral duty to stop them, but you would have no legal duty to stop them. And that really disposed of this plaintiff's legal argument, that we had a duty to, if we saw him losing a lot of money, we had as the broker, had a duty to stop him from trading.
What was right to call for margin in 1992?
Who I represented in that case was Lind-Co Futures, who was the intermediary IB. So you had Goldberg Brothers, was the clearing firm. Lind-Co Futures was the intermediary, and then they in turn had an IB down in Florida, which was the Capital Options Investments, basically a retail firm brokering options for their customers. I don't remember the exact event in the market, but there was an event in the market that caused some combination of Lind-Co and Goldberg Brothers. I believe they were in agreement. There was no dispute between the IB and the clearing firm there that margins needed to be raised just for the for risk purposes. And so they communicated that to, the IB that was actually dealing with the customers. The customers couldn't make the margin calls. They all had to be liquidated. It caused a lot of issues for this, retail IB that was working with the customers. And they lost a lot of business over that and I don't know if there were deficits coming out of it, but they probably didn't have deficits, but they they lost business because their customers were upset that they had to be closed out of their positions unwillingly, and they sued Linco saying, well, it wasn't reasonable what you did. And, and they had all these reasons why it wasn't reasonable, that essentially we went to court on that. We did get a summary judgment on that from the U.S. District Court in Chicago. And it had some really good language, but essentially the court said that these are risk decisions to be made by business people, and they're not subject to a standard of reasonableness, because you can't. You have to be able to take action to protect your firm. And we put in evidence about how people trade on margin, and that the clearing firm only gets a small amount to begin with, and they're exposed for the rest of that, and they're taking a lot of risk. And the customer agreement is very clear in giving them the right to change margins at any time. And the court agreed with us, and then we went. That was appealed to the U.S. Court of Appeals, and the Court of Appeals agreed with us as well. And so it really established that principle in law about the broker's great freedom. You almost have to want to, the way the law ended up is you really have to want to raise margins to punish somebody for reasons unrelated to the markets in order to be liable. It has to be that's strong of a deviation from normal business practices to be criticized or sued for raising margins on a customer.
What was Farmland Industries versus Fraser Parrott?
I represented, in that case, Heinold Commodities, which was the clearing firm, and its parent, the DeKalb Corporation, and they were sued. Fraser Parrott was the IB dealing with a big co-op in Kansas City called Farmland Industries. And Farmland Industries, they were trading on the New York Exchange energy futures, and they lost a lot of money. They were alleging that the trades were unauthorized, and that there were kickbacks involved, and so forth. But as the clearing firm, our defense really was, we didn't deal with you guys. We didn't do anything. I mean, your beef is with Fraser Parrott and not with the clearing firm. But we ended up a month-long trial in Kansas City in the fall of 1987. We at the end of the plaintiff's case, the judge dismissed DeKalb out and said, you got no case against DeKalb at all. He left Heinold in until the end of the case, and then the judge dismissed Heinold out of the case just before it went to the jury for decision. But then Fraser Parrott ended up having to go to the jury, and they had very prominent Chicago lawyer, Dan Webb, representing them, and they prevailed before the jury. And then we had, as Heinold, the clearing firm had a attorney's fee agreement in the customer agreement saying if a customer brings a case against us and loses, then we get to recover our attorney's fees. And so we asked them for the attorney's fees, made a demand, and of course they denied, they denied liability, denied the demand, and we ended up having to bring the same judge that in part of the same case, we brought an attorney's fee claim, and their defense essentially was that it's just not right for a defendant to collect attorney's fees. That's essentially what it amounted to. They say, well, we understand, when you have a collection case and somebody owes you money, and that you might have an attorney's fee agreement to collect the money they owe. But when you're just a defendant, it denies us our access to the rights to court, and it's against public policy for a defendant to collect attorney's fees. And there really was virtually no law on collection of attorney's fees by defendants at the time. And so we litigated that before the judge, and the judge agreed with us. He didn't grant us all the fees we wanted. He cut the amount down, but he did grant us fees. But he would not grant us prejudgment interest, which was something like 8 or 10% back then, under Missouri law. It was pretty hefty. And it had been quite a few years since, because this ended up, our trial was 87, and I don't think the attorney's fees were finally settled till 97. So, you had, it really increased the amount of the award by then. If the plaintiff hadn't appealed that decision, we just would have taken our attorney's fees and forgot about the prejudgment interest, I think, but they decided to appeal it. So we cross-appealed on the prejudgment interest, and the Court of Appeals said, yes, you're entitled to prejudgment interest. You have an attorney's fee agreement, and we'll enforce that agreement. And so we ended up prevailing on that and making some law on collection of attorney's fees by defendants.